There's a lot of bad information out there about ideas and software not being patentable. And I want to tell you, it is completely untrue. Ideas are totally patentable. Software is totally patentable, even though in some ways they're not. And let me explain what I mean by that. So with the example of software. So technically, you cannot have patent claims that say, I claim software that does X, Y, and Z. The law specifically says, hey, you can't claim software. But my practice is patenting software all the time. And so how do I do it? How do we patent software on an almost daily basis as patent practitioners? Well, we effectively patent software. So the way you would do it is a computer implemented method of doing X, Y, Z with the steps of X, Y, and Z, or a computer readable medium that when executed by a processor performs the steps of X, Y, and Z, or a computer configured to do X, Y, and Z. So while you're not literally patenting the software, you're patenting the method steps performed by a computer, or a computer that performs those steps, or a computer readable medium, as in, stuff stored on memory. You're protecting those things, and that's effectively patenting software. And so, while yes, people are nice and tricky, and they'll say, yeah, software is not patentable, and the attorneys are technically right. They're not really helping their clients understand the truth that, well, yeah, you can effectively patent software. Again, I do that on almost a daily basis. And I hate it when I see the bad information out there and people come to me and say, oh, well, we saw some stuff that said software isn't patentable, so we didn't try to protect what we had, and we've been selling it for a while. And at that point, they've forfeited patent rights. Again, public disclosures, public use offers for sale. And then they can't patent software that was really important to their company, would have been really valuable IP, but just because they saw some bad stuff about software not being patentable, they decided not to patent it, which, then they're leaving a ton of money and benefit on the table. Similar with that is ideas. There are some case law out there that says abstract ideas aren't patentable, and there's certain sorts of ideas that aren't patentable, but as long as you can describe the idea in sufficient detail, totally patentable. Again, it's one of those things, talk to a patent attorney about what is going to be patentable and what's not. There's sort of a gray area there. But again, people say, oh, just ideas aren't patentable. It's like, well, it depends on what you talk about when you're talking about ideas. With most inventors, what they're really asking is, hey, I have an idea for a product. I don't know exactly how it's going to work. I haven't made a prototype yet, but would this idea for this product be patentable? And yes, it could potentially totally be patentable. As long as you could describe it to one of ordinary skill in the art, how to make and use the invention. You don't have to make a prototype. You don't know how to actually have to do it. You can talk about all sorts of different variations. That's totally fine. So bare ideas can be patentable in addition to software. Hey, patent friends, if you want to see the full video that this clip came from, click this box right here, or click this box right here if you want to see a playlist of all the clips from this video. And be sure to like the video on your way out to support the channel. Thanks.